Hello everyone, joining us as my colleague in the events team is gradually letting people in from the waiting room. I know that I've met many of you in person, not had the pleasure of meeting some others here, but welcome to all of you. I'm Jo Campbell, I'm the Business Development Manager for our VWV Approach network. And I know many of the attendees today are from firms who are already part of the VW Approach arrangement. Others are here as prospects for the network, those firms who might be interested in joining. So as a very brief reminder, because I can also see that some of you have been members for a while, I think it's useful to have a refresh. VW Approach is a network for small to mid-sized law firms and other legal professionals, and provides you with a free arrangement through which you can refer clients whose work you can't do yourselves, and in exchange have that reassurance that we're not going to steal those clients away from you by virtue of our non-poaching agreement. Fee share if you'd like it, and then other benefits like the webinar that we're running today. So we sometimes have with our private client team, they're very active, and we're joined today by colleagues Rachael Armstrong, who's a partner in our Birmingham office, and Angharad Lynn, who's a senior associate in our London office. So our private client team does spread across all of our locations in Bristol, London, Birmingham and Watford, covering everything from very kind of straightforward wills up to complex estate and tax planning, and then on the other side, everything from estate administration through to contested probate and trust matters. So the kind of the full run of private client work. We do sometimes run events and invite along our VW Approach members. This is the first time for a little while that we've done one specifically for law firms. And this one very much is just tapping into some of our recent experience in those matters which slightly sit on the edge of what is the day-to-day wills and probate type work, wills specifically, to begin with. So we've got Angharad, who's going to start us off today. She has been growing her experience in cross-border estates and international assets. She's going to talk through what English solicitors need to know. And then Rachael will follow on talking about her recent experience of being involved in some insolvent estates and really providing some practical tips on what that might mean for you as a practitioner if you find yourself in a similar position. Questions are welcomed. I would suggest as we're going through that if you do have a question, if you're happy to pop it in the chat box. Many of you will have used Zoom on a frequent basis in the last 15, 16 months. For those of you who are less familiar with it, at the bottom of your screen, there's a toolbar and there's a chat function. So if you click on that, it gives you the option to ask a question. You can either signpost that question to everyone, which is the default option, but otherwise do pick my name or the VWV Plus events host, and we can raise those questions as we go through. There will be time at the end for 5 or 10 minutes for us to have open questions as well for those who prefer to ask their questions direct. Otherwise, copy of the slides and a link to everything that you need. A recording will be sent after the event. And I think that's probably all you need to know from me now. So I'm going to hand over to Angharad, who will talk us through cross-border estates.
Lovely, thank you, Jo. Hi everybody, my name's Angharad Lynn. I'm a senior associate in the private client team in London at VWV, as Jo has mentioned. And I'm going to talk about the sorts of things that we need to know as English solicitors when dealing with cross-border estates and international assets. So I thought I'd start with a little poll, actually, which I think Emma's going to bring up on the screen now, just to get an idea of what sort of work you're all doing. And I wondered if you could just tick which of the following apply and which things you've dealt with in the last year or so. So cross-border estate administrations with EU assets, cross-border estate administrations without EU assets, wills with cross-border assets in the EU or outside of the EU, and also non-domiciled clients. So if you could all submit your answers now, and then we'll have an idea of everybody's experience. Brilliant. So it looks as if quite a lot of people are dealing with all these assets, especially wills where people have got assets in EU countries. So we will be looking at that in a little while. Brilliant. So can I have the next slide, please, Emma? So today, many people have assets in more than one jurisdiction, and trends suggest that more than ever before, people are moving between countries to work, study, and live. And despite Brexit and COVID, these trends look set to continue. Cross-border estates are, by their very nature, complex, as it's necessary to take into account the interaction between the laws and the legal concepts of more than one jurisdiction, and also the taxation position. So I'm going to start by looking at the requirements for a valid will where there are international elements, and I'm then going to discuss what considerations should come into play when an individual with assets in more than one jurisdiction comes to see you to discuss their estate, and about the need to liaise with lawyers in other jurisdictions to give joined-up advice. When you're drafting a will with cross-border elements under the laws of England and Wales, it's necessary to ensure that it's both formally valid, in other words, admissible to probate, and also materially or essentially valid. And essential validity concerns matters such as ensuring that the testator has the requisite testamentary capacity. So where there are international elements, the test for capacity may be different in different jurisdictions. And it also covers matters such as whether the bequests in the will comply with the laws of the jurisdiction that governs succession. So, for example, if someone leaves their estate to the cat's home and cuts out their children, but the law that applies has forced heirship, then the bequest will fail. If there is any international element to the testator's personal background, the assets in the estate, or the execution of the will, it's important to check that the execution of the will is valid under Section 1 of the 1963 Wills Act. And if we go on to the next slide, we'll see that the will is valid, the execution of the will is valid if it conforms to the law of any of the following. So the territory where the will was executed, the territory where the testator was domiciled at the time of execution or death, the territory where the testator had their habitual residence at the time of execution or death, or a state of which the testator was a national. And if the territory or state in any of the above cases is Northern Ireland, the Republic of Ireland, Australia, Canada, or New Zealand, a will that's been correctly executed under English law is normally acceptable for probate. And this is really important when we're dealing with clients who may not be UK nationals, because while a UK citizen can execute an English will wherever they are in the world, a non-UK citizen should generally not, in case the execution does not conform to the law of the country in which it was executed. For example, other countries may require a will to be signed in front of a notary, or they may require a different number of witnesses. So that's really important when you're dealing with people who are not UK nationals. And if we can have the next slide, we'll look at which law applies. English law distinguishes between the law that governs the administration of an individual's estate and the law that governs the succession to this estate. In most civil law jurisdictions, there is no such distinction. The English laws governing the administration of estates and matters of succession are concerned with whether or not the English court has jurisdiction, and if it has, who can take out the grant and what the powers of the PRs are. So if we go on to the next slide, we'll see about how which law governs the administration. Where there are assets in England, the assets will vest in the English executors, and those are the ones appointed under the English will. And they will be the people with the right to deal with the property, even if the law of another jurisdiction applies. So if someone has a bank account in England, but died domiciled in the US, the assets will vest in the English executor, but he or she must follow the law of the appropriate US state, for example, New York. In general, an English grant of representation will only permit the personal representatives to administer the estate in England and Wales, although sections 1 to 3 of the Administration of Acts 1971 provides for the mutual recognition in England and Wales, Northern Ireland and Scotland of a grant of representation issued by the court in the place the deceased died domiciled throughout the UK. So what that means is there is no need to have a different will in a different part of the UK. So if somebody has assets in Scotland, there's no need to have a separate will there. And it's not necessary to have different executors. The concept of personal representatives, however, is not recognised in many jurisdictions, and instead the deceased's asset will vest directly in the beneficiaries of the estate. So that's the law that governs the administration. What about the law that governs the succession? If we have the next slide, please. Succession law will be decided differently by different jurisdictions, depending on the connecting factors that are accepted and used by that jurisdiction. Domicile, nationality, and habitual residence may be used. And under English law, it's usually the individual's domicile that will apply. But in other countries, for example, Switzerland and Denmark, it is residence that counts, and in the Middle East, nationality. When you first speak to a client, it's an important consideration as far as English law is concerned, is where the client is domiciled, because in the vast majority of cases, the law that will apply to the estate administration will be the law of the person's domicile. Domicile is a complicated concept, and it means different things in different jurisdictions. But under English law, it is broadly where the individual considers their permanent home to be. And this is the jurisdiction, therefore, where the main will should be made. Under English law, at birth, an individual's domicile follows that of their father, where the parents are married, and the mother if they're not. Changing domicile is a complicated process, and to lose an English or Welsh domicile of origin and acquire a domicile of choice elsewhere requires an individual to show that they have severed ties with their home country and have made a permanent home abroad. If a client is domiciled in England and Wales, or another UK jurisdiction, then on death, their worldwide estate will be subject to UK inheritance tax. But if they're not domiciled in the UK, only their estate in the UK will be subject to inheritance tax. And even that may be subject to double taxation treaties. It's important to remember that domicile under the common law is not necessarily the same as tax domicile. And for those living in the UK, whether or not their legal domicile is still their country of origin, they will be deemed domiciled in the UK for all tax purposes once they've lived here for 15 out of the last 20 tax years. However, they can still consider their permanent home to be in another jurisdiction, but for UK tax purposes, inheritance tax will apply to the whole estate. If an individual wants to demonstrate that they've lost their domicile of origin, they will need, as far as possible, to have severed all ties with their home country. And if a British national wants to show that they've acquired a domicile of choice then in somewhere like Italy and have very few assets in the UK, it is persuasive if they have their main will in the country in which they want to demonstrate their domicile, so in this case, Italy, and a supplementary will limited to their UK assets in the UK. Indications in the will that the individual wants their funeral to take place in the country of the domicile of choice and to be buried there is persuasive. However, whilst it's possible to state in your will that you want your domicile to be considered to be at a certain place, that won't necessarily be accepted by HMRC when the time comes. Can we move on to the next slide, please? Oh, sorry, that's domicile. Can we go on to the next one? Private international law. So which law applies? In England, private international law provides that immovable assets, such as real estate, are, on death, automatically subject to the succession law of the country in which they're situated. And this is known as renvoi, which is literally sent back in French. Movable assets, such as bank accounts, pass under the law of the individual's domicile. This is known as a schismatic system. For example, if a British person owns a home in Australia, private international law means that English law will send the succession of that property to the appropriate Australian state, so for example, New South Wales, and the renvoi will be accepted. So the law of the Australian state will govern the succession of the property. Other countries, such as Denmark, Morocco, and Brazil, have unity systems. where the whole estate must be dealt with under one law. And if immovable property is owned in such a country by a foreign national, the renvoi will be rejected and the whole estate will be governed by the law of the domicile of the foreign national. So an example of this would be if an English couple owned a property in Morocco and renvoi sends the succession of the property back to Morocco, Moroccan law would reject the renvoi, and so the succession of the property would be governed by English law. Can we move on to the next slide, please? One of the questions I'm frequently asked, and I expect you are too when it comes to clients with assets in multiple jurisdictions, is how many wills to make. On the whole, it's usually advisable to make 2 wills, especially where there's real estate in more than one jurisdiction. But even where there are only movable assets, it can still be worth making more than 1 will, and there are a number of reasons for this. Firstly, the local language. A will that's made in the local language will mean that the estate administration is able to proceed more smoothly, because the lawyers administering the estate will understand its terms. Secondly, legal terms don't always translate very well, and sometimes terms that do not exist in one country may exist in another and may have to be approximated, which can cause problems. Also, definitions of words can be different in different countries. So same-sex marriage may not be recognised, or a child born outside marriage may not be recognised as a legitimate heir. Also, the cost of probate will be reduced. For example, if there's only 1 will, it will be necessary to obtain translations, affidavits of law, notarized copies of the will, and it may be necessary for the application to be settled by the probate registry. Where there's a local will, much of this can be avoided, and the estate administration can proceed in the secondary jurisdiction alongside that in the primary jurisdiction. And having 2 wills can also ensure that common law legal concepts such as trusts don't cause issues in civil law jurisdictions, and I'm going to talk about trusts a bit later on. And of course, as discussed previously, a local will mean it conforms to local requirements for formal and essential validity. If we can move on to the next slide, please. There are, however, lots of points to look out for when you're drafting multiple wills. One of the most common problems to arise is that the subsequent will can revoke the original will. So it's really important to ensure that that doesn't happen. If the secondary will is to relate solely to assets in a particular jurisdiction, for example, a French holiday home and a related bank account, then it should be clear that it is limited to that. It's also important to avoid partial intestacy by ensuring that the main will relates to the worldwide estate, except for jurisdictions where other wills are made. So if a testator makes an English will limited to English assets and an Australian will limited to Australian assets, but also has assets in Spain, those Spanish assets will pass under the intestacy rules. So make sure the whole estate is covered. It's also really vital that lawyers in both jurisdictions work together to ensure that the wills work alongside each other. And whilst this can incur additional costs at the planning stage, the savings to the estate in the long run may be considerable. But what about a single will? If we go on to the next slide, we'll have a look at making a single will. Because some clients only want to make 1 will, some prefer it because they think it will be more straightforward. Others don't want to make a will in a language they may not understand. And another reason may be that an individual wishes to establish a domicile of choice, and it can be persuasive if there's no will in the jurisdiction they're trying to show they have severed ties with. There may also be practical problems with making more than 1 will, and this has been in evidence during the pandemic. In Spain, for example, most wills must be executed in the presence of a notary, and many clients have been unable to meet this requirement this year, and so they may want, as a result, to include their Spanish assets in their English will, even if at a later date they do go and make a Spanish will. Where a client does want to make a single will, it's really important to still liaise with a lawyer in the other jurisdiction, sending them a copy of the will in draft so they can consider it and ensure the assets pass as the client wishes. It's also really important to beware making leaving foreign assets in trusts if these aren't recognised in the territory where the assets are located. Can we move on to slide 12, please? So which assets can pass under the will? When you're embarking on succession planning, it's important to establish whether property will form part of the estate on death. As we all know, in common law jurisdictions, such as England and Wales, it's possible to own a property as joint tenants. And what this means is that on death, the property passes by survivorship to the joint owner and not under the will of the deceased. Couples do, of course, have the option of owning a property as tenants in common, meaning they'll each own a defined share of the property, which they can leave by their will. Whilst joint ownership is not generally a concept in civil law jurisdictions, the tontine method of ownership provides a similar solution in some civil law countries, such as France and Belgium. And while owning a property en tontine is not exactly the same as joint tenants because the rights are contractual, it is a way of avoiding forced heirship. Most civil law jurisdictions have matrimonial regimes, which is something we don't have in this country. And when a couple marries, they may enter into a community of property regime. This will differ from country to country. In some jurisdictions, the community of property will apply to all the couple's assets. In others, it will only apply to assets acquired post-marriage. Civil law countries often treat British nationals as having individual ownership, so that community of property will not apply, and this should be discussed when the British people are buying the property abroad. In civil law jurisdictions, forced heirship may be an issue. The civil law position is that fixed percentages of an estate must be left to children, sometimes to parents, and often to a spouse. And this will vary from jurisdiction to jurisdiction. And while we have testamentary freedom in England and Wales, we should not forget the 1975 Act, the Inheritance Provision for Family Independence, which means that there are limits to our freedom to leave our estates as we wish. And if we move on to the next slide, we're going to talk about the EU succession regulation, which has changed things since 2015. The EU succession regulation applies to deaths after the 17th of August 2015, and it's changed the rules on succession matters as far as most EU states are concerned, and has effectively put an end to renvoi for most successions involving member states. All EU states, with the exception of Denmark and Ireland, have adopted the regulation. The UK was never a signatory, although there was originally some confusion as to whether the UK was a third state or not. Brexit has clarified this point because clearly, now that we are no longer part of the EU, we are a third state. Under the regulation, if an individual owns property in any of the participating member states, then the law of their habitual residence will apply to the whole of their succession, unless they elect for the law of their nationality to apply, or they are manifestly more closely connected with another state. So a British national with a house in Spain can elect in their English will for English law to apply to their Spanish holiday home. And there are a number of advantages in having English law applying, such as the avoidance of forced heirship. If an individual from a third state, so a non-member state such as the UK, does not elect for his or her national law to apply, then the succession regulation does not abolish renvoi where the third state refers back to the law of a member state. So, for example, a US citizen with a house in France who did not elect for national law to apply, then French law would apply to the French property. And this is now clearly the case for UK nationals. And it's really useful actually for British people post-Brexit, because it's now certain that renvoi can apply. And what this means is that if a British person doesn't make an election in their will, then the rules of English private international law will apply. So renvoi will apply to immovable property abroad. So English law will refer back to the law of the country where the property is situated. So a British couple with a French holiday house who do not make an election will have their house in France passing under French law. And that can actually be quite useful from a taxation point of view, because sometimes there are allowances for children in EU countries, in civil law countries, which will be lost if everything passes straight to the spouse, as is common in the UK. And talking about tax, I'm now going to go on to talk about tax on the next slide. Because although it's now possible to choose for English law to apply to succession concerning property in mainland Europe, local taxes will still apply. In the UK, it's the estate which is subject to inheritance tax, whereas in civil law jurisdictions, it's the beneficiaries, not the estate, that pay inheritance tax. And each category of beneficiary, such as a spouse, a child, or a non-relative, will pay tax at a specific rate, subject to an allowance. If the entire estate is left to the surviving spouse, then the children's allowances will be lost. If there's more than one will, it's important to consider where the burden of tax will fall and to draft accordingly. Generally speaking, common law wills usually include a clause referring to testamentary expenses, and the burden of tax falls on the residue of the estate. However, according to Section 2111 of the 1984 Inheritance Tax Act, this is only insofar as the assets are vested in the PRs and situated in the UK. So in drafting a will, therefore, you should make it clear whether worldwide tax is payable from the English estate, or whether the tax payable from the English or the tax from the English estate should be limited to the assets that pass under the will. And I should also just quickly mention double taxation treaties, because where assets in the estate are subject to taxation both in the UK and abroad, a double taxation treaty may provide relief. And even where there isn't a double taxation treaty, the UK will usually give credit for tax charged by another jurisdiction. And if we can just go on to the next slide, I'm going to very quickly talk about trusts, because these are something which is really important to think about when you are looking at cross-border assets, because the tax position can be particularly onerous in relation to trusts. As you all know, it's very common to mention trusts in English wills, but many civil law jurisdictions don't recognise them, or if they do, they tax them heavily. The 1985 Hague Convention on the law applicable to trusts has been ratified by 14 countries, including Italy and Switzerland. France signed the convention but never ratified it, but in 2011 introduced a measure whereby foreign trusts can now be taxed in France. But what this means is if there is a trust in an English will covering property in France, it will be subject to French inheritance tax. In France, there's no inheritance tax between spouses and generous allowances for other relatives such as children. But trusts are treated as non-relatives, or they can be, and may be taxed at the highest rates. So for a discretionary trust, this can be as high as 60%. So it's really important to think very carefully about how you draft a will where there are assets in civil law jurisdictions. If it's not possible to make a separate will, or the testator only wants to make one will, the best way of dealing with assets in the foreign jurisdiction is to ring-fence them by creating a separate clause in which they are left as a legacy, and the legacy should not use the word trust. Where the testator is likely to be domiciled on death in a jurisdiction that does not recognise trusts, and you're drafting a secondary English will in England, the will should not refer to trusts. So use the word executor rather than trustee, and talk about a residuary estate and not a trust fund. Can we now move on to the next slide, please? I'm just very quickly going to mention resealing of foreign grants, because in the majority of cross-border estates, it will be necessary to obtain a grant of probate in England, even if one or its equivalent has been obtained elsewhere. But where the deceased died domiciled in a country to which the Colonial Probate Acts of 1892 and 1927 apply, and that's mainly Commonwealth countries, and a grant has been issued in that country, an application may be made for the grant to be resealed in order to administer the estate in England and Wales. And once resealed, the grant has the same power and effect to administer the estate in England and Wales as if it had been made by a court in this jurisdiction. And the same applies the other way around. So in conclusion, I would just like to say I hope this has given you an insight into some of the complexities and some of the things to consider when administering a cross-border estate or when advising clients with assets in more than one jurisdiction. And if you have any questions, I'll be very happy to answer them at the end. But I'm now going to pass on to Rachel, who's going to talk about insolvent estates.
Can I first of all just reiterate what Joe has said? I don't hold myself out as a professional dealing with insolvent estates. It has just been that we've had quite a few that have come into the firm in the last few months, and it came up as a topic that would be useful to explain how we've dealt with them and things for other practitioners to bear in mind. And it is quite eye-opening when you should be stepping away and letting an insolvency practitioner to actually deal with it instead. So if I go to the next slide, please. Thank you. All of you will have heard this. Your debts die with you. And every single client who comes in says that to me. Every friend that speaks to me says that as well. As you're aware, a person's death does not release their estate's liability for the debts incurred during their lifetime. There is a difference also between an insolvent estate and an illiquid estate. Today we're just going to be dealing with insolvent estates and the payment of creditors. Can you go to the next slide, please, Emma? So just to give you the relevant law and some of the sections that will be helpful with dealing with it and that are used by the trustee in bankruptcy. We've got the Insolvency Act 1986 and then the subsequent modifications. These are the main sections to be aware of. So section 284 is the post-petition dispositions. So if you believe that an estate is going to be insolvent, or there might be a point that it is insolvent, the trustee in bankruptcy can ask for any dispositions made after the date of death that they're going to be needs to be ratified, so they could be void. So you do need to be very careful whenever you are paying any monies out to beneficiaries or paying any creditors. Why exactly have they been paid? Have they been paid in the right order, etc. Section 339, transaction at an undervalue. Again, you need to make sure that if you are selling a property to a beneficiary, that they're paying the full market value for it, that it's being dealt with correctly. They can look back as well at transactions prior to death, and depending on who it has gone to, either 5 years or 2 years. Preferences would be if you've preferred one creditor over another. So as you're all aware, putting section 27 notices in place before you pay any creditors. Some families will come in and say, well, I've already paid the phone bill and I've already paid this. Make sure that the first conversation that you have with them is that they do not pay anything at all, because once they pay something, then they're going to be liable for the payment of all of the liabilities on there. So they should be making sure that they have not paid anything at all. Under section 365, there's a power of search and seize for trustee in bankruptcy. So this isn't something that you can get until you've got your until you've had your insolvency administration order. But these are extra powers that would be available to the trustee in bankruptcy. So this is when you should be considering, is that powers that you need instead of the normal powers that you would have with as a solicitor and dealing as an executor under the estate. Delivery of information. Again, there's extra powers for trustee in bankruptcy that you wouldn't necessarily have as an executor. And then section 423, transactions defrauding creditors. And that's an interesting one because there's actually no time limit on that that they normally have, either in the 2 years or the 5 years, if they can show that it was done to defraud creditors. Then you've also got the insolvency rules, and the main important part is the Administration of Insolvent Estates of Deceased Persons Order, 1986, which I'll refer to as the DPO if I refer to it further on. And this has allowed for the Insolvency Act to be applied to estates. I can go to the next slide, please. So the rules and duties of executor and trustee in bankruptcy, they're very, very, very similar in that they have to cash in or get as much money as they can for the assets that are there. They have to protect, in the case of the trustee in bankruptcy, it's obviously protecting the creditors. For an executor, normally it's protecting the beneficiaries of the estate and making sure you're getting all the money in that's possible to pay the beneficiaries. Once you know an estate is going to be insolvent, you have to, your first duty as an executor is always to the creditors. You cannot conflict that with a duty or any kind of false duty to a beneficiary, your main duty is to the creditors. So if you do believe an estate is going to be insolvent or there's a risk of it at all, just make sure that you are following best practice and that you're looking after the duty that you have to the creditors to get all the money in that you can. So the executor becomes the bankrupt. So as an executor, it is your duty then to submit the statement of affairs and to attend on the official receiver. So once you've given that to the official receiver and they involve then an insolvency practitioner, you step back to a certain extent. And then if the insolvency practitioner is able to realise enough assets to pay off the creditors, then they'll give the money, any additional money to you as the executor to be able to pay off the money to the beneficiaries as per the will or the insolvency. The first thing you should be doing, and the advice that you'll probably get from counsel if you were going to get advice in respect of an insolvency, would be immediately to apply for an insolvency administration order. And that's basically to allow for the date of death to become the date of the bankruptcy, and then for the clock to start either 5 years previous, 2 years previous, 5 years from date of death, etc. You need to realise the assets of the estate, or so you don't always have to get an insolvency administration order. And then on the slide after this, or a couple of slides later on, I'll explain the 3 options that you have. So you still might be dealing with an insolvent estate and dealing with it as an executor. So you still have to do what the trustee would do and realise the assets of the estate and make sure that you're getting in as much money as you can in respect of those assets. You need to then distribute it to the creditors in accordance with priority, and later on we'll go through the list of priority and who should be getting their assets first. And then you should distribute any surplus to the beneficiaries if there is any surplus on there. If you could go to the next slide for me, please. So there's 3 options when you're administering an insolvent estate. Luckily, the last one that I dealt with, we were able to deal with it by the deceased personal representative. So the 3 options are by the deceased representative, if you're not having to get a court order, and if it can be agreed with the creditors, under the court's direction pursuant to Part 64 of the Civil Procedure Rules, or under the Insolvency Administration Order. Just to give you a bit of idea of what happened with the one that I was dealing with, it was a gentleman who lost his wife. Realised when she passed away that the property was held joint tenants, so there's a right of survivorship and there was joint bank accounts. All the other assets in her name, there was quite a large amount of debt, and a lot of people were telling him, oh, the debts die with her, that's fine, you're okay. And I was able to explain to him, actually, the joint property that was held as joint tenants and any of the assets passing by survivorship would be set aside if the trustee in bankruptcy became involved, and that his priority now was and his duty was to the creditors of the estate, and he had to make sure that he was paying off all of them and getting in enough money to be able to pay them off and be open and honest with them as well. Once he realised this was the case, there was enough equity in the half share of the property to be able to discharge all of the creditors on there. And he was, I do apologise, I realise my windows are getting washed typically, so I apologise about the noise in the background. So the gentleman in question, he had a duty, as I said, to the creditors to make sure that he had been able to discharge all of them. There was a mixture of creditors on there, such as HMRC customs, mortgages, credit cards, etc. So he had to look at what had to be paid. He did suggest, again, paying off some of the smaller debts, like the credit card, for money that he had available, which I had to explain to him that he should not do until he had put Section 27 notices in place and was fully aware of all of the assets and liabilities in the estate as well. And he's been able to deal with the estate on that basis, and the creditors have agreed to that. If you can go to the next slide for me, please. The insolvency administration order can be applied for by the following people, so creditors of the estate. So the gentleman I was speaking to could have stepped back and let one of the creditors instruct somebody to deal with it. In that instance, it was felt that the creditors would have their own charges for dealing with it. So he did want to try and keep as much money in the estate as possible, and that's why he opted for that option. Personal representatives, which is what he was, it was an intestacy, so he was dealing with it as a PRN rather than as an executor. Temporary administrator, a liquidator, and a supervisor of any voluntary arrangement that the deceased entered into prior to their death. Now, if you can get more than 50% of the value of creditors, so not 50% of the creditors, the creditor hold 50% of the value of the debts, you can suggest when you're making the application for the insolvency administration order who you would want to put on there as the insolvency practitioner, rather than it going to the official receiver and then on to somebody else and making the application at that stage. But you do need to make sure that you have got the creditors at least, as I said, 50% of the value on board to do that. Move to the next slide for me, please. So the date of commencement of the insolvency, as explained, once you do get to the IAO, the date of the bankrupt becomes the date of death. So you do need to be aware that anything that you have done then after death, transaction-wise, as I said, they could be void pursuant to section 284, and they would have to then be reviewed by the trustee in bankruptcy. So you do need to make sure that everything is being above board, even your costs and the time that you've spent on it. There is a case of Dixon Kendall Freeman, where Kendall Freeman were ordered to pay back over £200,000 worth of fees, costs and interest. So just running up lots of costs, and if a client says to you, well, I would rather run up loads of costs than pay the creditors, that's not going to wash for the creditors. The primary the duty has to be to the creditors, and even fees to solicitors can be void and have to be paid back. So please bear that in mind as solicitors. It can require ratification by the court, and it may be that you then have to show, well, why was it a fair thing to do? So what's your defence for actually maybe transferring at an undervalue or less than what the court is saying it should have been paid for? Looking at pre-death dispositions, so again, it would be 5 years potentially from the date of death, or 2 years depending on who the transaction was with. If it was at an undervalue, preferences as well again. So if before the deceased passed away, he's paid off the debt to his son, whereas there was other debts that were due as well, then that could be set aside too. So it's always really, really, really important that you get a lot of information around the solvent estate as well. What exactly did the deceased do prior to death? And this is sometimes why it's better to get an insolvency administration order in place, because the trustee in bankruptcy will have more powers under the sections that I mentioned previously at section 365 and section 366312 to be able to get more information from companies, from people who've benefited, from creditors, etc., because they can demand the information for the bankrupt, and they can do search and seizure if there's non-cooperation from any of the beneficiaries or the creditors as well. So sometimes it can be actually the best thing to do is get the trustee in bankruptcy involved, because they can actually bring an insolvent estate back to being solvent and will protect something for the beneficiaries. The IAO is required within 5 years of death to contest survivorship. So you do need to be aware of the time scale, that if there is potentially an insolvent estate and they're looking to question a joint tenancy or a joint bank account, the IAO has to be put in place within the 5 years from the date of death. However, under section 423, you'll remember I mentioned previously that if there's a transaction defrauding a creditor, there's no time limit for challenging that. So that could be challenged at a later date if it has defrauded the creditor. Go to the next page for me, please. So assets that are included in the insolvency estate. So all assets held in the deceased name as of the date of death. is the obvious one. Jointly held assets passing by survivorship, which a lot of people forget about these, and they think, well, it automatically passes to the person, but they can actually be set aside, and they can be asked to pay that money back into the deceased estate, and for the tenancy to be severed and the bank accounts, the half share of the money. Also, if, for example, the money was held in a joint bank account, but actually it can be proved that it belonged to the deceased and it was not the surviving beneficiary's assets, had never actually paid anything into that, they could ask for more assets to be paid back. So this is again where the section 366 and 312 would come into play, because the trustee in bankruptcy can get more information than what an executor necessarily would be able to get from banks. As you're all aware, trying to sometimes get information from banks on a joint bank account is just torturous. Foreign assets, you need to be aware of, are there any assets abroad? Also, have any of these? Is that what the bankruptcy is starting? What are obligations to that? And that's where you need to make sure that you're getting proper advice in respect to that too, because each country deals with their foreign their assets and their bankruptcy in very different ways. Assets transferred or sold in an undervalue. So again, you have to look prior to death and post-death. It's not just anything that's happened after death. So investigations would go into, like I said, has there been any payments off of loans to sons or daughters or spouses that shouldn't have been prior to death? Has there been transfers of money out of accounts just to try and make sure that they, as they believe that debts die on your death, that and that's not the case. Preferences of payments to one creditor in favour of another, like I mentioned, that if, for example, you were paying a family friend or a creditor that you were aware of and had a relationship with in favour of another creditor, they can be set aside as well. Next slide, please. Okay, allowable expenses is a very small list. Reasonable funeral, so not big fancy wake or lots of drinks menus as we've seen all submitted. It is only the reasonable funeral expenses and what that would cost. Reasonable testamentary expenses, again, they have to be reasonable. You can't be that you're, as an executor, that they're saying, well, I just want to waste the money rather than pay the creditors and happy to pay your fees. That your fees and the fees that they're incurring on behalf of the estate could ask to be set aside, and you have to pay that money then back to the estate for distribution. So again, be aware that you're able to justify absolutely everything on there, and just going with a client that they've run it up is not good enough as well, that money would have to be paid back to the estate for the creditors. Reasonable administration expenses, again, you make sure whenever you're getting your expenses in, that you know, well, what was up to date of death and then what was after date of death, and make sure there is that split. We've had to make sure if there's a credit card, well, what was put through prior to death and what's been put through after death. What can we put into the pot that has to be repaid? And even, for example, one that I've had, it wasn't an insolvent, but a dog went into a dog's kennel prior to death and then thereafter death, and we had to ask them to very much split up what was the cost up to date of death and what was the cost after date of death, and what is reasonable. Next slide, please. Priority of payment of debts. So again, whenever you do have all of the money in, that you make sure that they're paid back in this order, so that you are making sure obviously your secured creditors are getting the money that they need, first of all, from any of the assets that secured their debt upon. The bankruptcy costs and expenses, including the reasonable funeral, testamentary, administration expenses, like we explained. Preferential debts, then, or the next one that goes on there, for example, HM Revenue and Customs. Also, if it was a company owned in wages, they come out of that as preferential debts. So there's a list of, you always just double check because they might fall under preferential debts as well. And then ordinary unsecured debts, and then the interest on them. And then you'll see how low down the list is that says when the civil partner or the spouse can be paid. It's at the very, very, very bottom after any ordinary unsecured debts. So that's when the spouse should be getting their money back, or any interest on that. and then any other postponed or deferred debts, and then any surplus then goes back to the PR for the executor to pay out to the beneficiaries of the will or the intestacy. So it is really important that you don't deviate from that. And we've all seen the banks that will say, oh, we've got a credit card, we're going to use the money that's in your account to pay the credit card if we don't hear back from you within however much time. That they should be going back to that bank and say, no, the estate is potentially insolvent. Please let us know of the debts, and we will have to put them through to see how much we can pay in the pound for each of the debts on there. So don't let them take that money. They shouldn't be taking it, and they will pay it back if you do ask them to do that. So make sure you're telling the client that as well. Okay, next slide, please. So this is my last slide, and it's just the recommendations of what you should, if someone walks in your door and even just mentions it or an inquiry comes in, that you are explaining the importance of it being an insolvent estate, and that they can't just go and do what they want with it. They have to have if they are the executor or the PR, they have to have the creditor's best interests at heart. That is the priority, and that's what the court will always look for. So if there's any suggestion of insolvency, apply for the IAO, unless in the case that I just explained, that we were able to say that there was, absolutely, once it had been agreed that the joint tenancy could be severed, there was enough money, more than enough money there to pay it. But if there's any suggestion, just get the IAO and pass it on to the insolvency practitioner for them then to deal with it. Speak to the insolvency practitioner. We have got a fantastic insolvency team here, and that's the reason why I have been able to deal with the estates that have come in, because I've had them to be able to go and give me advice, to sound them off about certain things, to get their input where it's been required, and then I deal with the normal estate administration stuff. So obviously do speak to BWV approach. And if there's something that we can help with, then we will, and Joe will be able to signpost that for you. Trustees have more powers than the normal executor and could bring an insolvent estate back to insolvency, like I mentioned before. So don't let them think, well, actually it's the bad thing to do. It's actually a good thing to do, because there might have been transactions that you're just not aware of, or that they, as an executor, if they're not a family member, that they might not be aware of too, that they need to protect themselves as executor. Be aware that your file might be scrutinised years later by the court. So it is really important that all of the fees on there are legitimate, but which they would be, but also that they haven't just been wasting costs for the sake of wasting costs by the executor, and that you are making your executor aware of that, that if you find that they are doing that, that you cannot undertake any more work, because it's not actually going to be the best way forward for the creditors of the estate. The sole duty is to the creditors. I've mentioned that a few times, and that's the overwhelming thing I would want you to take from this, that in an insolvent estate, the duty is to the creditors, not to the beneficiaries, not to the deceased. It's to the creditors. And there cannot be a conflict in the loyalty to the beneficiaries or potentially to the deceased. Put your Section 27 notices in place and make sure that nothing has been distributed until they've been fully in place, and that the beneficiaries are aware of what the assets, or sorry, the creditors are aware of what the assets are in the estate that's able to be divided between them. Always check the solvency of the beneficiaries as well. So as a side note, you should be checking it as soon as at the date of death for the beneficiaries, and also on the distribution. So you should be doing a bankruptcy search when you first get instructed and get the beneficiaries' details, so that you know that were they bankrupt at the time, whenever it came to them being able to be getting a gift under the will. And then that's the conversation you should be having when you're doing your wills with your clients as well. Is there a risk that any of the beneficiaries might be bankrupt? Because it might be then a discretionary trust will that you want to put in place rather than the standard absolute gifts. That brings me to the end of a flying visit to insolvent estates, and I know it's a lot of information. I'm hoping the sections on there will help you be able to refer back to if you have a case coming in, and to see what the claims could be made under, and just to make it very clear to the PRs or the executors of what their duties are.
That's lovely. Thanks, Rachel, for your time, and also Angharad beforehand. So we do have 5 minutes or so now for some questions. As I mentioned before, if you'd like to pop them in chat, then please do so. You are all currently muted for this meeting style Zoom format, but you are able to unmute yourself in order to ask a question direct if you'd like. Both Angharad and Rachel have touched on areas where we've seen quite different experiences. In the last 6 to 12 months, we've seen an increasing number of estates or inquiries being referred across to us where clients do have international assets and where Angharad has been able to assist. It is always worth bearing in mind that in situations where there are international assets involved in perhaps in jurisdictions where we don't have so much experience, we do have connections in other law firm networks, certainly across Europe. STEP has a really useful directory of practitioners in other jurisdictions. So you, by all means, make an inquiry, see if we can help in situations where you feel uncomfortable advising yourselves. If Angharad can help, she will. If not, we might be able to signpost some other options. Rachel's experience has been very different. I know she started off by saying she wouldn't profess to be an expert in insolvent estates. I think, Rachel, you said you've dealt with 3 in your 14 years or so of qualification. So it isn't a particularly common occurrence. But as Rachel touched on at VWV, we have the benefit of having an in-house insolvency team. So in order to deal with estates where insolvency is involved, we have a really kind of streamlined access to our insolvency practitioners. So in that sense, if it's a throwaway question that you've got on an estate that you fear might be insolvent or you want some guidance through the steps, our insolvency team might be able to help through the free inquiry service available to VWV Approach members. If it's more complex and instead you'd like to make a referral, then we can deal with that in the usual way. But any questions about either international assets or insolvent estates, please do get in touch with the VWV Approach team and we'll put you in touch with somebody here that can hopefully help with the matter. We've got no questions popping up and no one has seemingly unmuted themselves. Often at this stage, it does pop a little poll on just so that you can rate the event. So if that's available there, please do take a second to fill that in. We're going to have a little break for our events now over the summer. We'll be back in September, so just putting that events programme together now. So please look out for further details of upcoming events from September onwards. As you know, we often try and use this format where we're sharing our experiences of cases that we've worked on or particular work types where they might sit on the fringes of what you're doing or where they relate to the practice management, risk and compliance side of running a law firm business. So look out for that. There will be a follow-up email in the next day or two with a copy of the slides and a recording of the session. So I will just leave it to say thank you very much to our speakers, Angharad and Rachel, and to all of you for joining us. Hope you have a lovely summer, and it will be nice to actually meet up with some of you in person before too long. Let's keep fingers crossed.